what they call justice. So when you begin to look at law like that, in the case of Bello versus Attorney General for your state, the Supreme Court take 5-10 years. They know that at the end of the day, if you argue for 6 hours, it will be granted. So you just say again on the same old charge, when the Court of Appeal has said this court, including any other court in Nigeria, is prohibited from ever trying him on the same count charge. We will not serve the charge sheet. We only read it in the social media. And when I asked the prosecution today to give me a copy, they said they also don't have a copy here. They didn't have a copy here. So I told the court that what I would have expected would be that the prosecution should just have gotten up to withdraw that matter, because it constitutes an abuse of court process. That you, who has appealed against a judgment that said this man cannot be charged, you are the one who appealed. The appeal is extant and pending. It has not been decided by the Supreme Court. The same you is rushing back again to the same court that the Court of Appeal said has no jurisdiction to try this matter, to file the same count charge again against him. That's an abuse of court process. But what the judge did today, which I think was quite good, was to say both the first case and the second case are adjourned to await the hearing and final determination by the apex court of the land. Then why will Nnamdi Kanu, who has always wanted to be in the court for his trial, who detests the gulag, is presently kept caged away like an animal, who even instructed us, and we did, to write to the Court of Appeal with a reminder that he wanted to be present during his Court of Appeal case, which was decided in his favor on the 13th of October 2022. Why will Nnamdi Kanu, who has already indicated in a cross appeal against that case that he wants to be at the Supreme Court for the hearing of his matter, why will he suddenly turn around and say he's not coming to court? To me, that story stands logic on its head, and I don't buy into it at all. That is all I can say about it. But today is Monday. I will send a Jofo to go back there to go and find out what is going on.
Your mic's down, so
hear from us.
Your mic's down. So what?
You brought 2 matters on the course list today. 2 matters on the course list today as pertaining to your
About
client.
3, actually.
Yes. Okay. So the last one, we didn't quite get it when the judge also said that she will wait for the outcome of the Supreme Court. Can you shed more light on that?
And also on the plea that was on the plea.
3 matters came up today. The first one is the main case that has been existing here, which the judge adjourned in June this year to await the outcome of the Court of Appeal judgment. We had filed an appeal against her decision in April this year, dismissing 8 out of the 15 count charge. We were aggrieved that she still retained 7. So we appealed against those 7 counts to the Court of Appeal. And the Court of Appeal on the 13th of October 2022 agreed with us, faulted the lower court, and dismissed the remaining 7 counts. Counts 1, 2, 3, 4, 5, 6, 7, and 8. Not only that, the Court of Appeal, in the unanimous judgment anchored by Justice Adefoku Okoji, actually said, we hereby grant an order prohibiting Nnamdi Kanu from being kept in detention or tried or arraigned before the lower court or any other court in Nigeria. Most judgment anchored by Justice Adefope Okoji actually said, we hereby grant an order prohibiting Nnamdi Kanu from being kept in detention or tried or arraigned before the lower court or any other court in Nigeria on the same counts or the charge which he was standing trial for before his forceful, torturous, and extraordinary rendition from Kenya to Nigeria on the 27th of June 2021. So the court granted a total prohibition against Nnamdi Kanu ever being tried. One would have expected that the federal government, having lost an initial golden opportunity to follow the July 22 ruling of the United Nations Human Rights Working Group against arbitrary detention, which had ordered Nnamdi Kanu to be released forthwith and that damages, restitution, and compensation be paid to him. The federal government failed to take advantage, to take that lifeline. I wrote to Mr. President a 34-page letter with 3-page government filed an appeal to the Supreme Court against that judgment. And not only that, shockingly, they filed a stay of execution using civil procedural rules in a criminal case, because the criminal rules, procedural rules of the Court of Appeal do not have any provision for stay of execution in a criminal matter, because they do not expect it. And in the case of Gloria Mowari, the Court of Appeal, the same Court of Appeal had made it clear that you cannot stay execution of the liberty of a citizen. The facts were virtually like this. The Court of Appeal said, how do you want us to stay execution of a citizen's rights, fundamental rights? Release him. Release her. Ozekhome, my good friend, senior advocate of Nigeria, did that case when we were in civil liberties organization together. We all worked on it. But the same Court of Appeal surprisingly turned around and stayed execution of his own judgment. Staying execution of your own judgment is a way of saying, I was even wrong in a criminal matter. Hello, we have appealed against that stay of execution, the judgment itself, and we have also cross-appealed against the main judgment delivered on the 13th of December of October 2022 on some ancillary aspects, one of which was that it didn't matter whether they pronounced exactly on it that you must state the place and the date with specificity. So it is not just a case of saying, as the Court of Appeal said, that once the person, the charge has been brought to his notice and he knows the case against him, then it was enough. It was not a mere dressing. It's the law. And we have cross-appealed against that aspect, that the law has to be obeyed. We also cross-appealed against another aspect. You banned IPOB. IPOB said, you are wrong to ban me. I'm a legitimate organization, a peace-loving organization, clamoring for self-determination, which is recognized by all international instruments, including United Nations Charter, including the African Charter on Human and People's Rights, including the International Convention on Social and Political Rights, including the International Convention on Economic and Cultural Rights. So, asking for self-determination where you feel that you are marginalized in your own country and you are a dot in the cycle and you are not being reckoned with, it's not a crime. We saw IPOB members marching on the streets, blowing whistle, PPPP singing. We are Biafrans, wearing beret, carrying cordials, marching.